Some of the other highlights on subpart A, again, these uniform definitions should be very helpful. Everyone playing by the same rule book and the definition of supplies and equipment. Having that uniform threshold of 5,000 should make life easier for all of us in the room. Having computers be classified for the most part in a non-expendable personal property, not being required to be asset tagged, depreciated, and maintained in the asset inventory year in, year out, including software. Some agencies treated software because of its cost as a capital equipment. Generally not the case. It's now strictly based on dollar value. The clarification of distinguishing between a contractor and a vendor. The term vendor has been eviscerated from the federal grants landscape. We don't use that term anymore. If we have a third-party contractor, they're either a contractor or a lower-tier subrecipient. And OMB wants to know, I want you to know, that you can continue to use the term vendor if you want to. We don't care. We will define the applicable compliance standard by the nature of the relationship, not what you call the entity. So GDOT may call everybody in this room vendors. It doesn't matter from a compliance standpoint. Most of you in this room are lower tier subrecipients or you are contractors. So it doesn't matter what you're called in the contract. That doesn't define who you are. Indian tribal governments for years, for decades, if you will, have never wanted to be lumped under the same rule book as state governments. And that has happened, and OMB has promised to issue additional guidance on the applicability of all the super circular rules to tribal governments. That guidance has not come out yet. I'm not sure what's taking so long. Generally anything. We don't have any, do we have any recognized tribal recipients in Georgia? We only had one in North Carolina, so it made life easier. The clarification of those relationships and the flow down principles, I think, is helpful in determining applicability. More transparency. Here's one thing that's important. And this is one of the things that FTA took exception to in the 5307 program, but it is very much applicable to 5311 and 5310. Is that the federal agencies have to make a risk assessment before they can give you money. So how are they going to do those risk assessments? What factors are they going to use? We really don't have a lot of definitive guidance yet, but this is a hot topic in DC circles right now. So here are some of the factors that are stipulated in the super circular that the federal agencies have to use. And because GDOT basically stands in the shoes of FTA in its administration of the 5310 and 5311 programs, GDOT in future state management plans will have to identify for you guys how they will assess risk in awarding contract funds to you guys. And those risks are going to be based on elements of one, financial stability. That can mean a lot of things to a lot of different people. It generally will mean, yes, financial reserves. Do we have enough working capital to function adequately without threat of cessation of public or specialized transit services? Because all of FTA programs are cost reimbursement. We have to incur the cost, go through the bureaucratic cycle to get paid, right? Our ability to stand that cycle demonstrates financial stability. Quality of our management systems. How often do we have to send data to GDOT? Monthly, quarterly? How accurate is that data? How many times has GDOT kicked those monthly submissions back to you because of mistakes? That will be symbolic of the quality of your management systems. History of performance in compliance reviews. If you got reviewed in 2014 and somebody comes back in 2017, finds the same thing, i.e. you never fixed it, that will be a mark against your organization. Single audit results. I'm going to use your story that when you worked for that other agency, not the current agency, of course, that they had a finding of insufficient segregation of duties because they didn't have enough money to hire enough people that the auditors wanted to see. I can't tell you how many times I've looked at a 2017 audit and found something very comparable. I go back, I looked at 2016 audit, there it is. I go back in the 15 audit, there it is again. Joe Davies County in northwestern Illinois, I guess I had too much time on my hands. I went back all the way to 2001, same finding there. Each time I read the county's response. The county agrees with the auditor, but we do not have sufficient funds in the county treasury to justify additional personnel at this time. That finding repeats itself for what, a 17-year cycle. That will now be a mark against the organization. What should happen is when you get struck by that, the commissioners balk because they don't want to hire or spend money for more people. So you've got to sit down with the auditors and say, look, we can't hire any more people. What reassignment of duties do we need to make in order for you to mitigate this finding in next year's audit? Yes, it may mean you have to bring a third party in from the Department of Administration to augment opening mail that should be opened by the Department of Finance just to eliminate that insufficient segregation. Find out from the auditor what it's going to take. That's going to impact future grant awards. The ability to effectively implement statutory and regulatory requirements. You're supposed to do those, since somebody's mentioned Title VI programs, you're supposed to, there was an initial cycle, and they have to be updated every 3 years. We're kind of in the second cycle. Most state dots put people, you had to get it in this year, this group had to get it in next year, so they weren't looking at 85 plans in 1 year. I don't know how Georgia DOT did it, but you're on cycles, you're in the second cycle. We're finding a lot of rural transit systems were unaware that they had to update their Title VI plan every 3 years. They're out of compliance. That will adversely affect a grantor agency's assessment of your ability to comply with federal requirements.
For clarification, subpart C is applicable to transit agencies that are receiving funds directly from FTA, right?
That's correct.
And for us, for GDOT, for 5311, we are performing this.
Yes, but there are certain provisions in subpart C that you as the primary recipient will be responsible for carrying out, including the risk assessment.
Correct.
And I'm expecting FTA then to, when they issue 9041H, when they go into the chapter on SMP requirements, they're going to require you guys to outline how you're going to implement these risk criteria in your evaluation of subrecipient applications. So yeah, subpart C I mentioned earlier when I did the outline, primarily related to the federal grantor agencies, but because in essence FTA contracts with the states and then gives them the ability to take 10% off the top to pay for their administration of the 5311 or 5310 programs. FTA views them as standing in their shoes in the management of 5311 and 10 requirements. So this requirement will flow down and become the responsibility of GDOT in the future. Subpart D, this is the stuff that relates to you guys. whole notion of internal control. It's your ability to develop policies, procedures, and organizational structures that result in effective administration of the programs you've been funded to provide. And in a lot of cases, we're talking about the ability not to get your names in the newspapers. There's a fascinating little booklet that's published by the Tennessee Comptroller's Office. In Tennessee, they have a hotline. So if you think a government's misbehaving, you can call this 1-800 number, and it rings at the Comptroller's Office, and they begin a clandestine investigation of your complaint. And each year, at the end of the year, they compile all the complaints that were legitimate. And he publishes a book. It's like an audit, so it's usually the book isn't published until about 18 to 2 years after the period in which the ripoff occurred. But it's a summary of how they investigated these complaints of misuse of public dollars. And overwhelmingly, I'm shocked because guess where most of the theft of public funds is occurring? It's within the county sheriff's departments, it's within law enforcement, and it's within the county court system. It's people stealing court fines and other things of this nature. And Tennessee publishes this black eye book because it paints a black eye on the state of Tennessee and individual county governments and judges. Yet this comptroller does it every year. And it's kind of fascinating. These people who literally are under the banner of law enforcement are committing crimes. And not a good thing. Effective internal controls means your ability to recognize where we are at risk of having a crime committed and what steps have we taken to mitigate that risk. So, for example, we in transit tend to charge money for riding the bus, right? We charge the fare. How many people charge fares on their transit system? All right, keep your hands up. How many of you have locking fare boxes on your vehicles? About 3/4 of the hands went down. What are the drivers doing with the fare revenues during revenue service until they get back to the office? Who kept their hand up? Go ahead. Money pouch. Just has a zipper on it, right? And you might transport an individual with a disability, right? Lots of them. And under the ADA, the driver's obligated to leave his seat and render assistance. Where's the money pouch when the driver's out rendering that assistance?
Usually they have a footboard that folds down and it's inside the footboard.
Okay. But any passenger on the bus might see that, right?
Yeah.
And if we're doing ADA service, that technically is origin to destination service, it may be that the driver actually has to leave the vehicle to render the appropriate level of passenger assistance. And there's all that money just sitting right there. Our job is to develop policies and procedures to minimize the theft or loss of those project revenues. We develop procedures on fare collection, fare tabulation, reconciliation with our route match reports. I saw they were a sponsor, so I had to mention their name. Plus, I like to give Todd Allen a hard time. He used to work for me. It's our job to develop policies and procedures. That's why we'll see policies such as we require 2 signatures on a check. The same person who makes the deposit shouldn't be the person who does the entry, the GL, the general ledger entry into our accounting software. There should be 2 different people. In other words, we should create a system of checks and balances so that one personnel can't take the money and go to Jamaica. Where are we at risk? In transit, it's the fare collection process. Anybody know the number 2 area where we're at risk? Anybody give your employees credit cards? Well, I hear some no, but I heard some yes, didn't I?
Run express cards, like the fuel cards.
Yeah, P cards, fuel cards. And I'll tell you, just my personal experience. I'll pick on Tennessee again. The transit manager gave her husband the transit system fuel card. He was filling up his personal vehicle. Got a tip on the comptroller's hotline. He was convicted and ordered to pay restitution. She was the party at fault. For some reason, I can't understand why the district attorney did not prosecute her. She still has her job. There was a transit manager in Ohio, home state of RLS. We saw an unusual amount of volume on his credit card in the course of doing a compliance review. And one particular vendor showed up repeatedly, and it had a funny name that we couldn't relate to any business. A little further investigation revealed it was an adult establishment. He was going on his lunch break using the transit sedan with the county logo on the door to go eat lunch at an adult establishment. We'll leave it at that. And he was charging God knows what to the credit card, and he was handling those bills, he was paying those bills. Insufficient internal controls, because only he saw that credit card bill. Mark McGregor, who cut the deal with the mechanic, got away with it for 7 years because he was the only person responsible for receiving the invoice, recording the invoice, paying the invoice, one signature on the check. Many breakdowns in internal controls. Another Tennessee rural operator, just going through the recession, economic tough times, her and her lead driver decided that when they collected money from fares, it'd be $1 credited against the net cost of service in the grant. $1 would go to her, $1 would go to the lead driver. And they would be the 2 people who performed the counts. A driver got wind of this practice, actually attended an RTAP training session where they learned that the driver normally is one of the individuals of at least 2 individuals who were involved in the fare box count. And he wondered why it didn't happen in his transit system. He filed a private report, and we ended up installing, unbeknownst to the transit manager, a camera in her office. County sheriff did this, conducted an investigation. We got them on film. They stole $12,000 over the course of 18 months. And it's more than just the theft of that revenue. Because what do we do with fares? We have to deduct it from total operating cost, and that's what yields how much 5311 we're entitled to. If we underreport fares, we're increasing the net cost of service, and our organization is drawing down in any one invoice period more federal money than we're entitled to. That is a federal crime. It's a felony crime. So this is serious stuff. Even though you think you're only stealing 50 cents, who will notice? The federal crime, the United States Code 1801, doesn't distinguish in amounts. Whether it's $250,000 or $250,000, it's still a crime. We have to recognize within all of our financial management dealings where we are at risk. Put the necessary controls in place and make sure and monitor that those controls are effective in offsetting our risk. I started mentioning folks, particularly in the nonprofit sector, who would go through the trouble of writing an indirect cost allocation plan, submitting it to this beast known as a cognizant federal agency, and then never hearing another word back. Or we'd have situations where they develop an indirect cost rate plan, it'd be approved by their cognizant agency, so they would have an indirect cost rate of 13.7%. And they submit a grant to another agency, and that agency would say, we don't like 13.7, we're going to cap indirect cost payments at 10%. They did this via administrative fee out. Under the super circular, that's no longer permissible. Once you have an approved indirect cost rate from a federal cognizant agency, every other grant source must recognize that rate. And unless Congress has specifically capped indirect costs at 10%, they have to pay your indirect cost rate. Period. No exceptions. If your organization's been in business a long time, you'll typically note that your indirect cost rate doesn't move above or below that line very much in any one fiscal year from another. And so various bean counters at the federal level began to get the notion that we can approve rates for a multi-year period, and we're not going to have much impact on the amount of monies due our subrecipients, but we will have a substantial impact on the administrative burden in the preparation of such plans and in the review, negotiation, and approval of such plans. We can reduce administrivia. And so some federal agencies got into the habit of approving multi-year indirect cost rates. And that is now a permitted practice across the federal landscape, with the noted exception of FTA, who has not seen the wisdom of that policy and has articulated in FTA 5010 that you must submit indirect cost rates every year. And I believe that's due to inexperience at FTA. I said I wouldn't talk bad about them, now I am. And I'll stand by those comments. Unless there's a major shift in the financial resources of an organization, a major overhaul in the organization structure, your indirect cost rate doesn't move but a 0.5 percentage point year in, year out over decades. All right, now we have the new automatic 10%. If your organization has never had an approved indirect cost rate with the federal government, you are allowed to get 10% of modified total direct cost every billing period, and you don't have to do a thing. This is pretty significant, but it does have some issues. I mean, nothing, no justification. All you need to do is tell the grantor agency, and your auditor needs to note in their audit report that you've claimed the de minimis rate. That's it. If you've ever prepared an indirect cost rate proposal, you know this process just saved you probably 40 to 80 hours of labor. So this is kind of nice.
Rich, before you go too far, the cognizant agency discussion. So let's say we have a GDOT, like a letter from one of our subrecipient agencies says Department of Commerce, their cognizant agency approved a rate, say like 2017. They'll look at it again like 6 months after the close. Anyways, the point is, I don't want to keep getting confused. What's GDOT's role? If the federal agency has already said, we approve your rate, 46.4%.
You ask them for a copy of that letter, And then that becomes the rate you use in any contract dealings with that entity. That is your only option at this point.
That's what, okay, that was my understanding.
There are more options. You've got to make sure that the letter comes from a federal grantor agency. And you'll see a little later on this afternoon that because of the pass-through relationships at some agencies, if another entity that you're dealing with gets a comparable letter as a pass-through agency, which is what GDOT is. GDOT is empowered to review, negotiate, and approve an indirect cost rate in lieu of a federal cognizant agency. The preferred path of action is to get your indirect cost rate approved by a federal agency. But if that doesn't happen, then the pass-through agency can do it. If the pass-through agency is a state government and a sister department of Georgia government has done that, then you have a choice of either accepting the sister government's determination or negotiating your own with that subrecipient. OMB looks like, in my reading of all their guidance and supplemental Q&A, really wants state governments and service pass-through to accept the determination of whoever served as the lead pass-through authority, but they don't require it. So there's a situation where an entity may have two indirect cost rates in the absence of having one with a federal cognizant agency. But if they have one from the federal agency, you guys have to accept it, like it or lump it. I know sometimes the DOTs think those rates are too high, they don't like to pay for it. And part of the dilemma here, to my mind, is a little bit oversold, is nobody wants to pay for overhead. We want to pay for units of service. We're in the mobility business. So if we have a choice of paying, $20 for fuel, oil, gas, and driver salaries, we'd rather pay that than pay for multi-purpose building insurance. That doesn't buy us a ride, this does. But the fact of the matter is, in Georgia, there's only so much, the pie's only so large, and you guys have, 85 subrecipients? You gotta slice that pie 85 ways. By the time you're done slicing, the slice of the pie may not even pay for transit organizations' fuel bill for the year. So it really becomes a matter of financial policy decision at the local level. Is it worth us going through the rigmarole of going after indirect costs if it's not going to bring another dime to my organization? And in most cases in transit, because there isn't enough 5311 money to go around, we can spend that money on operations, and that's usually what most policymakers will determine.
Rich, I know the indirect cost we've been talking about is with a subrecipient, but if we drill down one more level, is a third-party operator, if a third-party operator submits an expense called indirect cost for reimbursement to our subrecipient, is that an eligible expense?
It is. And there are approval steps. That's just assuming that they are a lower tier subrecipient.
They're not a nonprofit.
They're a for-profit entity. Then we get into the argument that I will talk about probably tomorrow. My advice, and I can't emphasize this point too much, is that I would never, ever, 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 ever in a million years enter into a cost reimbursement contract with a private for-profit operator, because I am bringing down upon my neck and shoulders a level of pain that will plague me throughout the grant year and all the grant years of that contract. And I don't want to see a line item by line item invoice from that vendor. I want that vendor to figure out what it costs him to deliver a unit of service on my behalf. And I want him to tell me, charge you $1.65 a mile, I'll charge you $52 an hour.
A unit rate.
And then all I want to do when I see that invoice is I want to count units times the approved rate, and I don't worry about it. Now that said, and so now I've vastly reduced my contract administrative burden throughout the contract year. I have increased my procurement burden because when I go out to bid, I'm going to tell these guys, here's my bid form, I want you to give me a price per hour for 2019, 2020, 2021. Then I want you to attach to that price form your spreadsheet calculations where you're showing me, I told you to bid on 60,000 annual hours, you tell me what you expect your costs are, and then I want to be able to divide 60,000 into that bottom line and come up with something akin to his bottom rate. And I'm going to look at all the things in his line items to make sure that he's not paying administrative officers $700,000 a year, that he's not charging me $7 a gallon for fuel. I'm going to do some quick checks. And that is part of what is known as a cost and price analysis that I should be doing with every procurement above the micro purchase level.
On the front end. Yeah.
On the front end, and if I'm confident that the rates that he appears to be charging me for fuel, that the administrative salaries of corporate officers who will be involved in the management of my program on my behalf appear reasonable, then I can rubber stamp the cost and price analysis, and I feel good about paying him $52 an hour. And then my job to the billing clerk, make sure they've documented the hours properly, and I can do that from the schedules, from the manifest. I have a very easy check and balance system in place. I'm not being overcharged. And if he's making 15% profit, great.
So to summarize that, you're saying like on cost reimbursement contracts, essentially they're paying for the cost, they're paying all direct costs, so you would not have an indirect cost plan if you have a cost reimbursement?
Well, it depends. And, you know, I'll use consultants. I'll pick on RLS now. When GDOT hired us, you're paying me so much per hour. And you have to evaluate whether or not a senior associate is worth whatever it is that was on our proposal. You have to evaluate whether our administrative and general overhead of 96.45% is reasonable in comparison with our competitors. You can ask for a G&A overhead audit. AASHTO produces an audit guide that our auditors follow in producing that G&A overhead audit. We follow a different set of rules on cost reimbursement contracts than what lower tier subrecipients follow as public and nonprofit agencies. The super circular applies in terms of its cost principles to recipients, subrecipients, and lower tier subrecipients. As a general rule, it does not apply to contractors. We have a whole nother set of rules known as federal acquisition regulations that apply to contracts with private operators. And if we enter into a cost reimbursement contract with a private operator and we're expending federal dollars, we would apply FAR principles to the evaluation of those costs. We would not look at 2 CFR Part 200.420 through 475 to determine cost allowability. And FAR will place limits that if I'm a GS11 and I'm proposing to use a GS11 on one of your contracts, and I hold an appropriate job title and job duties, FAR will outline the limits of compensation on certain types of classifications, like executives, CFOs, and the like. So it's fairly a complex topic. This is why procurement, this is all part of your procurement planning, in my mind. If you know the prospective offers to my invitations or solicitations may come from the private sector, then I'm probably going to want to develop a unit rate billing structure rather than a cost reimbursement rate structure. It's easier for me to audit, it's easier for me to verify, it's easier for me to manage, which is why I'm so strongly in favor of unit type pricing. And let's do the evaluation up front. We do it one time, and then we're good for the rest of the year. And if it's a multi-year contract, I look at the escalation factors from year to year. I might be good for 5 years. And that is a rather routine matter in normal procurement activities when you go out to hire for transit management services, transit operations services. One of the things that's killing state dots right now is we have something known as the 5311F program. And that's the intercity bus program. And state dots have not had a lot of history of directly contracting with for-profit operators. Tennessee tried to do it with a for-profit operator and had no experience in monitoring and auditing a for-profit company that did things other than just the 5311 service. And Tennessee DOT got out there to audit them, and the auditors ran themselves into the ditch because they couldn't figure out what was part of the regular business practices of the organization versus what was part of the 5311F funded services. There was a lack of clarity in the definition of the original project scope that got them into trouble. And that's the same thing that will get you guys into trouble if you contract with the private sector. And I worked for a number of years as a instructor for FTA in the late 1980s under their entrepreneurial services program, which was intended to enhance the level of private sector participation in public transit service delivery. So this is kind of in my wheelhouse, and I'm a big proponent of private sector participation. I just think there are easier ways from a public policy management standpoint that we can go about that contracting, where we have a win-win situation. So a long-winded answer to your question. Okay, a little bit ahead of schedule. Why don't we go ahead and take a 15-minute break, and I'll see you folks at 10:20.